Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. A cupcake sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Thanks so much for coming and hanging out with me today. It's Thursday, November 7th. The time is 4:20 p.m. here on the East Coast. And, another day, some more droppings on the Karen Read case, as we've come to call them. Put some rubber duckies in the chat, members. Some more droppings. Interesting tidbits that we should go over. Things that happened yesterday after we covered the SJC arguments. So I thought, let's come back and do it all again because we're here for it. Seems that Beverly Cannone is going to stay on the Karen Read case by special order. But first, I found a very interesting story that I thought you guys might be interested in regarding a town selectman in Norfolk County. Let me know if any of you have seen this. I'm going to play the news clip. Then we can discuss because what the duck? Somebody just said in chat that there's a Delphi show on, let me just pull that up. There's a Delphi show on Hulu and that I'm in it. Kelly? A show on Hulu about Delphi and they were talking about YouTubers covering it and I was on it. Like they showed my clips or they just said my name or I need more information because nobody asked me if they could use my stuff. I did not give them permission to use my likeness, although hopefully it was good, whatever you saw. Somebody said it was called Impact. I don't know if that's the thing you're talking about, that it's 35 minutes long. So I find that interesting. If that's true, I'll go watch it. Thank you for pointing that out to me, Kelly. And you guys can point it. Yeah, right? You can't just swipe your stuff. My agent's going to get mad. What is that? Yes, you are correct, Lady Di. Let's take a look for those of you who haven't seen this. This is it's a little bit interesting. This is what you get when apparently Michael Marcy is your district attorney in the town of in the county of Norfolk. Listen to this, you guys. Prepare to be outraged. This came out yesterday.
We're talking about a board of selectmen chair accused of trying to use his public position to influence a police investigation. Tonight, that case is closed, but it's opening up a host of concerns. No one coming to the door at John Jeffrey's Dover home today, a day after criminal charges against him were dismissed. Jeffries, until last week, was the chair of the Dover Board of Selectmen. The case all began last July when his car and 2 guns inside it were stolen out of his driveway. Dover police eventually obtained charges against him last month for improper storage of a large capacity firearm and leaving a firearm in a vehicle. He was also charged last month with 3 counts of intimidation of a witness or police officer, accused of using his position as selectman to try and intimidate the police investigating him. But yesterday,
3 counts of witness intimidation against the police officers that were investigating him. You heard that right. You didn't mishear that. You heard that absolutely right. Michael Marcy dropped all the charges yesterday, the day before, or the day before that, whatever the day before his arraignment was. Listen to this. Let's just take that back because I didn't see the documents and I want to see the documents. Oh yeah, look at that. 268 section 13B. We know that witness intimidation statute yet. Well, don't we? We know that witness intimidation statute because so many of you, the viewers, have been charged under that statute, as has Aidan Carney many times, as has Richard Schiffer, the rubber duck bandit. Okay, so listen to this. A selectman from Dover, everything dismissed against this guy by Michael Morrissey, your district attorney.
With 3 counts of intimidation of a witness or police officer accused of using his position as selectman to try and intimidate the police investigating him. But yesterday, one day before his arraignment, prosecutors dropped the case, writing, officials from the town of Dover and Mr. Jeffries have entered into an agreement which at present would negate the need to pursue criminal charges.
The average person who was charged with these offenses would never in a million years have had these charges dropped.
Lawyer Juna Perkins, who is running to replace the current Norfolk DA, says the charges were too serious to be dismissed under these circumstances.
What message is the DA sending?
I think the DA is saying that decisions can be
Fill in the blank, guys. What message is the DA sending? Chat, go for it.
made based on who you know and who you are, rather than true justice.
The Norfolk County DA declined to comment on the dismissal or Juna Perkins' comments there. The town of Dover says Jeffries apologized to the police department and it is satisfied with the outcome. The stolen guns have not been recovered. Brittany Johnson, 5 investigates.
So he apologized to the police department and they're satisfied with that outcome. So if Richard Schiffer apologizes for the rubber ducks, are you going to dismiss his charges too? Are you ducking kidding me? Are you ducking kidding me? Every single person who is running for district attorney against Michael Marcy should be clipping this and using it as an advertisement. She was, right? She was on Young Jerks. Yes, that's what she was. I'm sorry, I don't know her name, but she's running for district attorney and she went on there and she did an interview. Yes, the law only applies to some people. That's exactly what they're saying. That is exactly what they're saying. If you're a town select board member, you can have all your charges dismissed. Just say you're sorry to the police. He wasn't just charged with intimidating witnesses. He was charged with intimidating police officers that were investigating him. Are you kidding? I have no words. I have no words. Wow. Just wow. Selective prosecution, selective enforcement, selective just about everything in the hellhole that is Norfolk County. Sorry if you guys live there. I didn't mean to say that. But you know, if the shoe fits, what the duck? So yeah, so this happened yesterday. This is a special order. This is an order for special assignment in the Commonwealth v. Karen Reed. It was filed, well, it's not stamped, but it was filed, I believe, yesterday in, today's the 7th, Norfolk Superior Court. And it is entitled Order for Special Assignment. It says, it is hereby ordered that the Honorable Beverly J. Cannone, Associate Justice of the Superior Court, is specially assigned to hear the above captioned case for all purposes. The clerk's office will notify all counsel of record. In future filings, the parties shall note prominently in the caption that the case is specially assigned to Judge Cannone. XOXO, Michael, looks like Ricciuti or Ricciuti. I'm going to say Ricciuti, Michael Ricciuti, Chief Justice, Norfolk Superior or Norfolk County Criminal Court. So she's getting a special assignment. We had discussed that she was getting rotated out of her position, which is common or which is standard protocol for the position that she was in. And, I would say it's not uncommon. She's already tried the first case. There's nothing nefarious about this at all. There's no, I don't think there's anything unusual about it. She's already tried the first case. She's fully familiar with the case. So, typically, the judge who tries the first case would also sit on the retrial because they don't have to bring up another judge to learn all about the case. I mean, think about how much is involved in this case, right? But you will also note, filed on the same day, StreamYard, we need to talk because you don't make things easy for me, is the same order in the Walsh case, except the Walsh case was taken from Judge Cannone and assigned to Judge Diane Frenier. Now it's important to note that the Walsh case is pretrial right now. So that case was taken away from Judge Cannone, as was Turk. Turk was also taken from her and reassigned to a Judge Mark Halal, Hallal. So I have that one as well. I just want to check the date on that, make sure they're all the same date. They're all done yesterday. Yep, all done yesterday. Turk is also in its pretrial stages, which there's a conference on that on Monday that I wanted to cover. All three of those cases involve some of the same players and same investigators that are involved in the Karen Read case, including Michael Proctor, who's under internal affairs investigation for his behavior during the Officer John O'Keefe murder investigation. He was also involved with the Walsh case and the Turk case. So interesting. Judge Cannone gets to hold on to Karen Read, and two other judges get assigned to Turk and Walsh. Quack, quack. Good one. Good one. What do you make about that? Yes. Hi, Kelly Reed. Oh, yeah. I've got it on my calendar. We're going to court next Wednesday. We're going to court, and we might have some more motions to hear because here's what else happened yesterday. Hank Brennan is earning his money. He's earning his money because he wants to go back after Gretchen Voss for all of her notes and emails. You may recall, I think it was all the way back, I want to say all the way back in January of last year. Wow, that was a long time ago. We're going to look at that hearing again. I thought we'd pull it up for old time's sake, for good old time's sake. January 18th of 2024, Commonwealth made the same motion. Gretchen Voss is a reporter. I think she's a freelance reporter who wrote and published an article regarding Karen Read all the way back in September of 2023. Met with her a couple of times and had a phone conversation with her. Or maybe she met with her 3 times. 2 of the interviews were videotaped. One of them was not. One of them was supposed to be off the record. The other 2 were with her attorneys. And Gretchen Voss wrote this, I don't know, hit piece. I don't know what you want to call it, for Boston Magazine. But I have some really, really interesting thoughts about this. Here's the thing. First of all, that you should know is that unlike most other states, Massachusetts is one of a handful of states that does not recognize a journalistic privilege. So in New York, reporters here and journalists are so protected that they never have to give up their sources and their source material and their confidential notes, any notes that they take. It's a privilege that New York recognizes, and most other states recognize it too, but not Massachusetts. Not Massachusetts. So this is being called a renewed motion because they did already make this motion once, and it was denied in part and granted in part, and that was all the way back in January of 2024. It seems like a lifetime ago, doesn't it? Seems like an absolute lifetime ago. But Hank Brennan is here. He's earning his $2.50 an hour, and he I'm sure he's keeping timesheets. Matthew Farwell's case is in federal court, so that is not a state court case. It's a totally different judge, totally different court system. So thank you for that question. It's how they always do it, Tinkerbell. You know, it's how they always do it. Hi, Mitsame. Thank you so much for wanting to become a member. If you look in the video description of this video, there should be a link. So that's the thing. I don't know. It's weird if you have YouTube on your phone. Like if you close out the chat, there should be a join button. You know, if you have an iPhone, sometimes it's not there. So what I do is I always put it in. The link is in every video description. So there you go. Thank you so much. There's an iPhone link that I think one of the mods has that they can drop. Perhaps if you have an iPhone, there's a link for special link for that. And I'm sure they'll be happy to help you. Thank you so much for loving my channel. I appreciate you. Melissa, thank you so much for tuning in from Australia and for your a super sticker and a super chat. It says I'm liking your new intro so much. It stays in my head all day. I know it's like an earworm. It's like an earworm. Thank you. Turd Ferguson, who's a viewer. Her name is Melisa, wrote and produced that song for me. And it seems that a lot of you like it, and I like it too. Love it. Kirsten, formerly Auntie Bev's verdict form. Oh, you got to think of something new now, Kirsten. There's so many Kirstens and Kristens in this chat. When Bev denied Lally this motion last pretrial, if she allows it this time, can Karen ask for a dismissal? Dismissal of what? Her entire case based on her granting the motion? No, it wouldn't rise to the level of dismissing the case. But I do think this could be helpful. So let me explain to you why. All right, let's get there first. Now comes the Commonwealth. Okay, so this is called Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss and or Metro Corp. Now comes the Commonwealth and respectfully requests this honorable court, pursuant to Rule 17 and Lampron, reconsider its order of January 23rd, 2024, and issue a new court order to Boston Magazine, Gretchen Voss, at this address. The Commonwealth respectfully requests that this court order Gretchen Voss and the keeper of records of Boston Magazine to produce to the criminal clerk's office the following. 1, the complete audio record of all interviews between Gretchen Voss and the defendant, including but not limited to June 20th of 2023 and July 13th of 2023. So we got June 20th, 23, 7, 13, 23. So those are the two times. Okay, so here's footnote 1, which says, to the best of the Commonwealth's knowledge, Voss engaged in 2 audio recorded interviews with the defendant on June 20th and July 13th, 2023. 2, all handwritten notes of any conversation between Gretchen Voss and the defendant, including but not limited to the off-the-record interview of the defendant. Footnote 2. The unrecorded interview has been referred to as the third interview between Voss and the defendant. 3, all emails between the defendant and Gretchen Voss or Boston Magazine. 4, all text messages between the defendant Gretchen Voss and or Boston Magazine. 5, all voicemail messages between the defendant and Gretchen Voss and our Boston Magazine. So they want the audio, notes, emails, texts, and voicemails. The sought-after information is evidentiary and relevant, cannot be obtained reasonably in advance of trial without this court order, and is being done so as to not unreasonably delay the trial. Lastly, the application is being made in good faith and is not a fishing expedition. Argument. This court has previously found that the materials sought by the Commonwealth meet the requirements of Rule 17. However, the court also attempted to balance the public interest in every person's evidence and the public interest in protecting the free flow of information to journalists. See petition for the promulgation of rule regarding protection of confidential news sources and other unpublished information. That's from 1985. To that end, the court ordered only that the information that was on the record should be provided. The court did state that if, after reviewing the redacted on the record interviews, the Commonwealth believes it is entitled to further information, it is not precluded from reasserting its motion to this court. That is what you call a motion that is denied without prejudice. Without prejudice means you can bring the motion again in the future. I need this frog to get out of my throat. The Commonwealth respectfully requests that this court reconsider its prior order and provide all the sought after information. In support of these requests, the Commonwealth states the following. The defendant has made tactical and repeated admissions outside of court regarding her activities during the evening of January 28th and the early morning of January 29th of 2022. The defendant's statements to Voss are not protected by any privilege, and there is no legal basis to limit the Commonwealth's entitlement to all the defendant's statements to Voss. The defendant engaged in 2 recorded interviews with Voss. The first recorded interview occurred on June 20th of 2023. The Commonwealth was provided a 3-hour and 19-minute recording for this interview. The second recorded interview occurred on July 23rd, 2024. The Commonwealth was provided a 14-minute recording for this interview. First one's 3 hours and 19 minutes. Footnote number 3, which says, during a January 18th, 2024 hearing, counsel for Boston Magazine informed the court that the June 20th, 2023 interview lasted approximately 4 hours and the July interview lasted 2 hours. The defendant engaged in a third-party, I'm thinking third-party complaints right now. The defendant engaged in a third interview with Voss that was not recorded. During the unrecorded interview, Voss took notes. At some point, the defendant sent text messages and left voice messages for Voss. The interviews include the presence of at least the defendant, the defendant's attorneys, and Voss. The audio recordings provided are saturated with redactions. The June 20th audio was riddled with approximately 50 redactions. The July 13th audio was marred by approximately 100 redactions. Many of the redactions occurred during discussions and admissions pertaining to critical issues in this case. Many of the redactions include interjection by the defendant's attorneys. Oftentimes, when the recording resumes after redaction, the recording has diverted or redirected to a different topic from the one that was interrupted. An example supporting relevance of redacted information and the Commonwealth's right to all the audio recordings, including statements of all participants in the redacted statements, is presented below. The excerpts that follow are just a few of many examples demonstrating why the Commonwealth is entitled to both the defendant's complete statements and the statements of other participants in the interviews. Otherwise, the Commonwealth will be deprived from providing full context, the defendant's admissions, and impeded from providing the fairest picture of the defendant's statements and admissions to the jury. I'll tell you my thoughts after we're done. But my first thought here is, this time, because they know they don't have any evidence that Karen Read actually hit John O'Keefe with her car, and they also know that their blood alcohol extrapolation equation is junk, they're going to try and rely on her admissions. her alleged admissions, the things that they think are admissions, like I hit him, and whatever else she may have said in passing to Gretchen Voss, just like the motion that they made to get the Ted Daniel interview of Karen's parents and brother from whatever network that is that Ted Daniel works for. They're trying to show that she admitted something to her father. And they're also trying to get his phone records. Like, the whole thing is such a fishing expedition that it's beyond, it's deep sea fishing at this point. All right. We're going out to the canyons and we're fishing for marlin. Like, that's what this is. This is not even like, going to town dock and looking for a fluke. Okay. This is deep sea fishing right here at its finest. In her June 20th of 2023 interview with Voss, the defendant professed. Now she's professing things. I thought you only profess things like love, but whatever. 16/19. I'm not sure what, maybe that's the line number or some sort of reference on this tape. Like the minute, I don't know. It says 16/19. Answer: I drinking like I normally would. I tend to talk a lot when I'm out in those, and when people see the bar footage, I'm very much in the middle of a group, and Liza's seen it too. This is at McCarthy's and at the second bar as well, that I tend to stop drinking. And, I'm very extroverted around people when I'm in that environment, but we weren't, and then it's redacted. And then Misty and Eddie says, or Misty and Eddie, as the closed captions would often refer to him, Misty and Eddie. Somebody changed their name to Misty and Eddie. You answer, yeah, I had in my 20s, I had and then she talks about her medical issues. Likely as an explanation for why she doesn't drink a lot. Because as we know, because it's been made public, she suffers from not only MS, but also Crohn's, and had multiple surgeries. Multiple surgeries when she was in her 20s. I can't even remember how many surgeries, but a lot of surgeries. The redaction interrupts the defendant's admission on a critical issue, her drinking alcohol on the night in question. When the redacted audio resumes, the discussion has shifted from consumption of alcohol to a medical issue. This is exactly what they're looking for. They're looking to see if she admits to how many drinks she had, or she admits to being hammered, or if she admits to, knocking into walls on her way out of there because she couldn't even walk, because they know that the BAC extrapolation and the science behind it is junk. And that even their own witness who testified at trial, who worked in the lab, when he was cross-examined and he was asked, in order for this to be accurate, don't you need to know exactly when her last drink was? And he said, yeah. And whichever attorney was, I can't recall, said, so do you know when her last drink was? And he was like, yeah, no, nobody told me that. We don't know. She could have gone home and been so angry at John that she drank, a couple shots of vodka. It's completely unreliable. I still can't believe it was even let in. But here we are, back in the twilight zone. Further, in her June 20th of 2023 interview, the defendant makes more admissions relative to the issue of alcohol consumption. This is 44/24. Question: and is the level of intoxication pretty high here for everybody? Answer: it's happy. Question: yeah. Answer: it's question because you'd had a lot to drink, right? Answer: I wouldn't say I'd had like a normal amount. Question: what's normal? Answer: like a vodka tonic every 40 minutes. Footnote 4. This claim of a vodka tonic every 40 minutes is undermined by the video evidence from a bar named C.F. McCarthy's. Really? Who testified about that? Who testified about how many drinks? Improperly, by the way, about how many drinks Karen had at C.F. McCarthy's. Anybody remember who it was? Oh, well, it would help if I opened the chat on my screen. Yeah, it was Yuri Buchanek who testified to that based on his review of the video Yuri's math teacher, if you're here today, we need you, because how did Yuri add up all those drinks? He was not the proper witness for that. The receipt from the CF McCarthy's showed, correct me if I'm wrong, 2 beers and a Tito's, or 2 Tito's and a beer. So there's that. Just because Yuri counted how many drinks, how many glasses maybe the bartender even handed her. I don't even know how that was admissible either. But you know, here we are in the world of the upside down, where evidentiary rules don't seem to matter. So there's that. Vodka tonic every 40 minutes. Remember, they were at they're at CF McCarthy's. Karen was at CF McCarthy's for about an hour and a half. So that would be, if her math is right, 2 drinks, right? And then an hour and a half at Waterfall, which would be 2 drinks. She's already said in one of the interviews that we saw on television that she had around 4 drinks. And she also said she didn't even finish the one at the Waterfall, or, you know, she had brought, everyone else is claiming she brought one with her to the Waterfall. So, you know, there's that. Question. Okay. And so are you feeling like buzzed? And I'm not judging. I'm just trying to get a sense. And she says, yeah, buzzed. And of course, these italics are, although they don't say it in their papers, which they should, you know, emphasis added. They don't say that, but I guess we should just assume, because it's an audio recording. So there couldn't be italics in an audio recording. Shortly after these admissions, the interview continues. 45:20. Question. Yeah. Okay. So then Jen's trying to get you to go, and you're insisting I'm leaving with John. And then there's a redaction. All right. So Jen is trying to get you to go. That backs up whose testimony? Ding, 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 ding. Karina Kolakithis. Remember Karina? One of my favorite witnesses. Karina testified. I'm breaking from the papers, just to remind you. It's not in the papers. Karina testified that Jen McCabe was all over Karen, like, you're coming with me. I've got a surprise for you. You're coming with me. You're coming with me. In fact, Karina said that John and Karen were so lovey-dovey at the bar that when she got home with her husband testified, my wife said something to me like, why don't you treat me like that? Or how come you're not like that with me in public? Or something to that effect. Answer. Yeah, I had a water. I had sips of water at Waterfall. Yeah, but I hadn't had anything to drink before about 9:15 that night. Everyone I met up with that night had been drinking long before. I mean, that tracks, because she got to McCarthy's a little before 9. Maybe she didn't get served her first drink until 9:15. Everyone I met up with that night had been drinking long before. Question. Yeah. Answer. I went out, so I would assume their level of intoxication was higher than mine. The defendant's admission of drinking a vodka tonic every 40 minutes is followed by a redaction shortly after. Immediately after the redaction, the resumed audio then demonstrates a non sequitur claiming to consuming sips of water at the Waterfall. Don't go chasing waterfall. Reminds me of our playlist that we made for this trial. That's a good playlist, by the way. The post-redaction assertion that she drank sips of water at the Waterfall is contradicted by the defendant herself in her interview with 2020, where she claimed 40/25, footnote 5, which says transcript of 2020, season 46, episode 33, Karen Read, The Perfect Storm. Answer. I had probably, she says, I had probably about 4, not 4 that I completed either. I didn't drink maybe more than a few sips at the Waterfall. Okay. Okay, so what's your point? Notably, the defendant's June 20th, 2023 version. This is what she keeps changing her story, all these versions of the story. Notably, the defendant's June 20th, 2023 version, claiming to have consumed sips of water at Waterfall, is also contradicted by evidence presented at the defendant's previous trial. What evidence? Oh, Yuri Buchanan's testimony? Because the receipt from C.F. McCarthy's was accurate. Wasn't that the only receipt that was ever entered into evidence? Was the one from C.F. McCarthy's? Because I don't think that they ever showed a receipt from the waterfall, right? And I think the bartender, oh, well, here we go. We're getting into the bartender at the waterfall now. Yeah, Buchanan, I can't use that word on the stream, so please don't put that word in there. If you don't know what it means, don't Google it. Said she had 9 drinks and had receipts. Yeah, and he never showed them. Another example supporting the relevance of all participants' statements is exemplified in the July 13th of 2023 interview, where Voss again explores the issue of alcohol consumption. Voss refers to the bartender at the waterfall on the evening of the alleged collision and questions. Question, she said to me that we never served her. Okay, this is Gretchen saying to Karen, the bartender at the waterfall said to me that they never served you. Karen says they didn't. Mr. Jackson says never said, never served her. Answer, I didn't drink there. Question, okay. And then there's a redaction. So, okay, then I need to go back. For some reason, I thought they had like your drinks by the time. Karen says, I was at a bar before and they knew by the bills. Question, that the bar before. Karen, but I didn't really drink at the second bar. I just socialized. And this is the same girl. She's heavy. She's talking about the bartender. Question, yeah. Answer, there's only like 2 bartenders. That's the owner's daughter. Oh, Gretchen Voss calls her gruff. She says she's gruff. She calls the bartender's daughter, the owner's daughter, gruff. Oh, that's not going to play so well in the civil case where the waterfall's being sued. Oh, I'll talk about somebody's daughter like that. Answer, she testified before the grand jury that I didn't appear drunk. I was talking. I was fine. There was no arguing. And no, she didn't serve me. I never went to the bar. Answer, yeah, okay, interesting. So I must have conflated the 2 places. And there's a redaction. Answer, okay, all right, redaction. We were at both places for 90 minutes. So 90 minutes at the end of the night with no alcohol. Question, right, redaction. Answer, I told her that we were, redaction. Question, yeah. Answer, she said 3. Did you hear her say that? Redaction, to be found by the 15th. I don't know what that means. Without the full unredacted audio of all the defendant and participants' statements, the Commonwealth will be unfairly blocked from obtaining and providing the jury relevant evidence that places the defendant's admissions in full context. Oh, wow, they're really reaching now. Even though they had Trooper Paul do 2 supplemental reports or a supplemental report with photos and video, and then they went and hired another expert once Hank Brennan came on board, they still want to find something, anything. There's no legal basis to preclude the Commonwealth from obtaining this relevant evidence. The defendant's statements are not hearsay and are instead substantive evidence admitted for its full force of proof. The other participant statements are interrelated to the defendant's statements, are necessary for completeness and context, and likely contain withheld statements of the defendant. I'm going to ask you. If Karen Read said that she was drunk, don't you think that would have been in Gretchen Voss's article? Don't you think? When a defendant, assisted by her attorneys, deliberately undertakes a public relations campaign, saturating the public with statements likely to reach the potential juror pool, they also run the risk that statements may not be beneficial and incriminatory. The helpfulness or unhelpfulness of the statement does not direct legal basis for disclosure. Further, all participants' statements provide necessary context to the defendant's admissions. Statements made by the attorneys in this context are afforded no legal protection. And that's true. Anytime there's a third person in the room, any of your conversations with your attorney are not privileged. Moreover, it is likely the redacted portions included group discussions about the topics. It is likely impossible to fully parse the defendant's statements from the other participants speaking in the group contained in the redactions. There is no recognized reporter privilege in Massachusetts. It is well settled that news reporters do not have a constitutionally based testimonial privilege that other citizens do not have. There's some case law here. The two cases analogized and considered by the court, first, John Doe, and second, petition for the promulgation of rules, blah, 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 do not prevent the Commonwealth from obtaining the sought-after information. In John Doe, the SJC noted that it is recognized that common law principles may justify the denial of enforcement of a grand jury summons issued to a news reporter. Specifically, the court evaluated a motion to quash subpoenas to discover the identities, and that should say discover. I'm going to edit as I go along with my red pen. To discover the identities of confidential news sources, and undertook an analysis to weigh the public interest in having every person's evidence available against the public interest in the free flow of information. Where the reporters had demonstrated that their claim of damage to the free flow of information was more than speculative and theoretical. In petition, blah, 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 the court discusses the governor's press shield law task force's suggestion that the scope of a press privilege extend to protect from compelled disclosure the identity of confidential sources. The court decided that in light of the many drawbacks to rulemaking in the present circumstances, it is inappropriate for this court to promulgate a rule establishing a reporter's privilege. Consequently, we dismiss the petition. Well, I mean, it's so interesting for a state that doesn't seem to like rules very much when it comes to protecting things like confidential sources of a reporter or their confidential materials used in investigative reporting. They don't like those rules, but they do like rules when it comes to witness intimidation. Like if it hurts a witness's feelings, you can be charged with felony, like for leaving rubber ducks around town with some stickers on the bottom, or for standing outside across the street from somebody's pizzeria with some signs, or, but if you're on the town council in Dover and you witness intimidate some police officers who are trying to prosecute you for, your giant gun that you stored improperly. Yeah, that's okay. We're just going to dismiss those charges, right? Wow. In both cases, the source sought to be discovered was unknown and confidential. This case does not involve a confidential source or confidential informant. Rather, the defendant made a tactical decision to be interviewed. There's no legal justification enabling a defendant to pick and choose what statements can and should be disseminated to the public. The off-the-record promise has no legal import, and this Commonwealth does not recognize the private agreement between the defendant and the news sources. It is simply a debt the Commonwealth has not contracted for. Dun, dun, dun. Anybody who's ever being interviewed by a Massachusetts journalist know that saying off the record means absolutely nothing. It is simply a debt the Commonwealth has not contracted for. You know what they did contract for? A hired gun, to retry Karen Reed because nobody in their office wanted to touch it, to the tune of $250 an hour for a cap of $75,000. Do you think that's why they couldn't prosecute the town selectman for his guns, because they ran out of money because they're using it to hire Hank Brennan? I mean, am I the only one who feels like I'm in the Twilight? Can I have some Twilight Zone emojis in the chat, please? Thank you, loves. There's nothing confidential about the defendant's media interviews with Voss and numerous other media outlets. The defendant's efforts have been directed, open, and notorious. Oh, notorious. They're notorious. The defense strategy is opposite of confidential. The defendant cannot avail herself of a media strategy to publicize and promote her claims to the public at large and the potential jury pool, while simultaneously advocating to excise statements and admission that are not favorable to her cause. All right, I'm going to go out on a limb here and say, or just remind you anyway, of Michael Morrissey's hostage video from August of 2023. We watched it together several times. It's 5 minutes long, where he stood in front of a wall of books, law reporters that were out of order. Some of them were upside down, taped a statement, maybe on an iPhone. I don't know. It wasn't a press conference because there was no press there. He taped a statement that seemed like a hostage video because it to us, to me, in my opinion, looked like he was reading a statement that somebody had drafted for him while somebody else was standing off camera holding a weapon. Maybe it was that selectman from Dover holding a weapon while he read the statement about how these witnesses were all being intimidated, and this has to stop. Michael Proctor was never at 34 Fairview. Michael Proctor was never at 34 Fairview. These people are innocent. They're just doing their civic duty or whatever the hell he said. And when the defense made a motion that Michael Morrissey should be allowed to be called to testify at the Karen Reed trial because of all of the things that he said during that statement, which was, in my opinion, a strategy to publicize and promote his claims to the public at large and the potential jury pool, the judge denied that motion. Again, shield and sword, shield and sword. No, Mr. Morrissey shouldn't have to testify because, but, the defendant, let's just release all of her. This is how it's going to go. I'll tell you this right now. In its prior order, this court commented that requiring Voss to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential is not an issue that this court should be concerned with. Voss should never have made such a promise to the defendant. Again, this is not a confidential source to anyone. Voss attributes the statements to the defendant in the interviews, and everyone in the public knows who made the statements. Lastly, the Commonwealth agrees that this case has extraordinary public attention and scrutiny. However, much of this attention has been at the hands of the defense. Some of it at the hands of the district attorney. By releasing that video that was so unprecedented, in his own words, this is unprecedented. It was so unprecedented that Misty Annetti said during one of the court hearings when he was arguing about it, that video that Michael Morrissey made is being shown by law professors to teach their students how not to be a district attorney. I'm just saying. They have made numerous press appearances and publicized this case. Who's they? You want her attorney's statements too now? Are you going to try and introduce her attorney's statements into evidence? Are you going to make her attorneys witnesses now too? Is that going to be your next idea? Well, they were there for the interview, so now they're witnesses, so now they can't represent her anymore? Is that? It's just interesting. I literally just picked up on that just now. It just came to me. Voss's fear for her own safety and that of her family has developed in part by the defendant's strategy. Okay. She's in fear for her own safety and that of her family, and now you want to subject her to more of that? That's horrible. Nobody should be in fear of safety. But now you want to subject her to more of that, is what you're saying. Okay. There is no damage to the free flow of information by allowing the Commonwealth's request because it is the defendant and her team who provided the information to the news sources. The Commonwealth has not sought any information from any confidential source of Voss's or Boston Magazine's article, but only information provided by the defendant's team and the defendant herself. Commonwealth respectfully requests, so they want information provided by the defendant's team. That's interesting. The Commonwealth respectfully requests that this court allow the Commonwealth's motion. Footnote 6. If the court is concerned about public disclosure of this information, the Commonwealth would agree to a protective order preventing the dissemination of any of the requesting evidence without prior authorization of the court. Oh, well, here's something interesting. Look when this is dated. October 18th of 2024. Oops, I didn't mean to do that. But it was just filed yesterday. What was the date of his hiring, Brennan? He was hired when? We went over the contract like the other day. Was it before or after October 18th? Maybe. XOXO. An affidavit in support of this motion is attached. For the above stated reasons, this motion should be allowed. XOXO. Hank Brennan, specially appointed ADA. Adam Lally, ADA. First thing we've seen his name on in a long time. And it may be because this was drafted in October. And they forgot to change the date. Laura McLaughlin. Huh. Well, how long is this document? It's only 2 pages. Here's the affidavit in support. And that's dated 11/6. Oh, so interesting. The shenanigans, the lack of proofreading. The lack of proofreading is mind-numbing to me. How many attorneys do they have in that office? Hundreds? While we're here, everyone, all 2,894 yous, smash the like button, please. I'll turn off the air conditioning, make you watch the fan until you throw up. Some of you might feel like throwing up already, so that would be really awesome. It's like the YouTube protocols, procedures, and courtesy. YouTube courtesy, we'll call it. Here's the affidavit in support of the Commonwealth's renewed motion. Oh, look at Yuri's math teacher coming in before I even knew it and gifting 5 memberships. I shouted you out anyway. Love you. Thank you so much for that. And to the 5 of you who are randomly gifted or grifted, those of you who are randomly grifted Yuri's math teacher's gift, thank you. Or welcome. You're going to like it here. Thanks to Irish for becoming a member, and Mitsame. And also, thank you to Miss Jones, also known as Dr. Jones, for being with me for 2 months. And Tracy says, good luck getting anything from Ted Daniels, in my opinion. Interestingly enough, I haven't seen any opposition to that motion yet. I wonder if they're just going to show up the day of, which is next week, and argue, because we're going to look at the argument that from last January when the guy from Boston Magazine came in and remember Bev was fawning over him, swooning. Tracy said, we'll see. It's not going to be up to Ted to, he's going to have attorneys that are going to come in for him that represent the network. And this is what they do. They argue about this stuff probably a lot because it's Massachusetts and there's no privilege there. So I'm sure they have a full legal department. Cannone is gross. Voss is gross. Thanks, Dublin, for coming to Boston and for hanging out with us today and for the deuce. And mom to all 4. Thank you for becoming a member. Oh, hi, Uncivil. I don't have no interest in disagreeing with you. I'd love to discuss with you the merits of Karen Reed's Supreme Court argument. Since we might disagree, could be a fun discussion. Love you. Thanks for the 5. We'll talk about it. Furious, Cannone was replaced on the Walsh case, but specially assigned to Reed. Yes. Did you watch the beginning of the stream? Because I went over those papers. Are you? And she was taken off of the Turk case too. Ingolf Turk was the guy who allegedly confessed to murdering his wife, and then she was found in a pond behind or near his house with rocks in her yoga pants. So she was taken off of Turk, and she was taken off of Walsh, who is accused of cutting his wife up into pieces and distributing her all over town. That's a no-body murder case. That was also assigned to Cannone. The difference, in my opinion, is that both of those cases are pre-trial, and Cannone's already tried the Reed case once, so I'm not really seeing anything nefarious about it. But I'm sure some of you are going to disagree, and that's why, that's why we discuss these difficult topics. Thanks, Sue, for becoming a YouTube member. Here's the affidavit in support. Fixes in. Walsh and Turk. Oh, all right. Contract was signed in 9/23. Okay, thank you, Shari. So that motion was drafted after he had already been retained. And yeah, it's pretrial again, but exactly. But she knows the law of the case. That's my point. She knows the law of the case. She knows what happened the first time. Not that motions that did not succeed last time may be able to succeed this time, but for another judge to get up to speed on a case that was a trial that was 9 weeks long and has something like, I think we're into the 400s on documents now. It's a lot. I'm just telling you that it's not uncommon for them to keep this case with the same judge that tried the first case. It's just not. I know that's not what you want to hear, but I'm not always going to tell you what you want to hear. Affidavit in support of Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss and or Metro Court. This just reminded me of a song. I think in song lyrics, and this is a really random reference. Anybody remember Steve Forbert? Steve Forbert had a song. It must have been back in the 90s, or because the name of the song was Call, Fax, Email. Call, fax, email. Call, fax, email. Soon. Like, why are you not calling, faxing, or emailing me? Steve Forbert. He used to play at little comedy clubs here on Long Island years ago. I'm muted. Will is here too? Sup? All stars. It's all star night. What's a fax? What's a fax? Kevin the Sally Port camera. Come on, dude. You're the one who's filming in, mirrored fashion. You don't remember a fax machine? Because you are probably all the way back from the 80s. All right, onward. I, Hank Brennan, hereby state the following information is true to the best of my knowledge and belief. Well, he doesn't say my name is Hank Brennan, so there's that. Wonder if he saw my show where I dug into him for that. I, Hank Brennan, hereby state the following. I'm the special prosecutor assigned to the defendant's case. I'm moving to produce records in the above captioned matter pursuant to Rule 17. We have become so familiar with Rule 17. The Commonwealth alleges that on January 29th, 2022, while intoxicated, the defendant struck John O'Keefe with the rear of her Lexus SUV and left him to die in blizzard conditions. Okay, here it is, with the rear. I'm going to point out everything that I hope the defense can use. Because, I'm here to help. Nobody's paying me, by the way. I'm just here to help. With the rear of her Lexus SUV. So Trooper Paul's thesis of John O'Keefe being hit with the side. Didn't he say like the side quarter panel, like the side of the car hit him? Well, it's the rear. Now they're going to go with the rear. Remember in openings, they said that Karen Reed struck John O'Keefe at 12:45 a.m. And then they had to change their entire theory when it came out that she was already connected to the One Meadows Wi-Fi by something like 12:36. Yeah, that's kind of like this. So now she struck him with the rear of her car and left him to die in blizzard conditions. Okay, again, there was no blizzard at 12:20 or whatever time it is now that they're going to say that she hit him. It had begun to lightly snow. Yes, Team Brittany. Hi, girl. It's my pen pal. Maybe another defendant in a whole other trial will come forward and confess to this. I don't know. You think? Team Brittany, who is my only pen pal, I say that because people have been writing me emails and like they want me to pick their kid up in California and buy some plane tickets and fly them to meet their mother in South America, and she'll give me 10 acres of land. So I say I give out my email. I will read your emails. I don't always respond to them. I'm going to put another caveat on that. Please do not send me emails and ask me to forward them to another YouTube creator. Okay. I have one person who's emailed me like 10 emails a day. Please forward this to Andrea Burkhart. Please forward this to this person. Please forward this. I am not your secretary, and I do not have a secretary. But thank you so much for taking an interest in other people's cases. But what I would suggest is most creators have an email in their channel page, and you can go there and you just click on a little box that says you're not a robot, and you can find their emails. Yes, Sarah. Sarah, you in shock and horror? Like literally 10 a day. Can you forward this to Mark Betterow? Can you forward this to, and it's all different people. Can you forward this to, I don't know, Will, if anybody's ever asked me to forward anything to you. But it's like, no, I don't even respond. It's the block button's coming next. Yeah, Madam Secretary. Right, exactly. I'm not your secretary. I don't work for you, but I mean, like due diligence. Just do your due diligence. You can find out how to contact these people. Don't stop clogging up my inbox. Oh yeah. It is more interesting behind the scenes than you guys. Maybe we should do that one night, Team Brittany. Like we do members only about like all the stuff that goes on behind the scenes, or just like pull up a whole bunch of twidiots, with their Twitter law degrees and like just prove them wrong on every nasty thing they say about me and others, and how they're trying to teach other people the law with their Twitter law degree because they're Jennifer McCabe's self-proclaimed bestie. Oy. After the arraignment, the defendant has appeared in interviews with numerous media outlets, included but not limited to interviews given to Gretchen Voss, Boston Magazine, 2020, Dateline, and Vanity Fair. They're coming for all you guys next. You forgot Ted Daniel. Commonwealth Rule 17 request includes the request previously made by the Commonwealth, along with additional requests not previously addressed that are relevant material. Undersigned counsel has listened to all the produced audio, okay, relative to the defendant's interviews with Gretchen Voss, and has separately read transcripts of both interviews. Commonwealth's motion is made in good faith, is not a fishing expedition, and is likely to produce relevant information. Well, I mean, I guess everyone's entitled to their opinion. XOXO, signed under the pains and penalty of perjury. Is this the only state that says pains and penalties of perjury? Because we don't say that in New York. But, it's kind of puritanical, I guess. You guys, I mean, I don't know. The 6th day of November, 2024. XOXO, Hank Brennan, specially appointed district attorney. And that is, in fact, dated yesterday. Well, this could turn out to be kind of interesting because here's what I'm thinking. Let me share this with you. Where is it? All right, here it is. What's good for the goose Come on, man. All right, get rid of this. Get rid of this. All right. No. Here's the Boston Magazine article that they're referring to. Oh, well, I just clicked on it. It took me to an ad. Hold on. Here's what's interesting about this. So many things. I have so many thoughts, so many interesting things about this. June 2023 is when she met with Karen for the first time. July 13th of 2023, she meets with Karen for the second time. Who else was she meeting with around that time, you ask? Well, oh, what happened? What happened was, anybody remember the Betero bombs? Remember the Betero bombs, you guys? Who else was going out to dinner with Gretchen Voss around that time, pursuant to her text messages that were released in the Betero bombs? Do you remember? KP. Yep. KP. What had happened was KP was also meeting with Gretchen Voss. They even became good friends, apparently. They were going to dinners together, apparently. So wouldn't it be so interesting if Mr. Betero requested from Gretchen Voss all of her recordings with KP that she took in the writing of this article? Wouldn't it be so interesting? Because there's no journalistic privilege in Massachusetts. And isn't KP a defendant in one of the cases against Turtle Boy? And wouldn't everything that she said to Gretchen Voss be discoverable? Huh. Because KP was not a confidential informant when it came to talking to Gretchen Voss. And even if she said to Gretchen Voss off the record, they don't recognize that in Massachusetts. You can't be off the record in Massachusetts. So I wonder what kind of recordings she has of KP. And I wonder what kind of notes she might have regarding her interview with KP. And I wonder what kind of emails, voicemails, text messages between KP and Gretchen Voss exist. What do you think? Kate Peter. Kate Peter is the one, Amethyst, who, if you were here for me during these Betero bombs with regard to Aidan Carney's case, had the private phone numbers of Tully, special prosecutor Ken Mello. And she was working for them, apparently, maybe. All that's been demanded in the Aidan Carney case to maybe or maybe not set up Aidan Carney with regard to the charges that were brought against him, which landed him in jail for 60 days. That had to do with Lindsay Gattani. Yeah. Email me that idea so that I can forward it to Betero. I think you wrote that. That's hilarious. Kirsten, I'll email and you can forward it to Betero. Better call Betero. Isn't that interesting? I mean, if that's going to be the law of the case, I mean, listen, Judge Cannone has been very reluctant to make new law in Massachusetts, like, for example, calling a jury back just to ask them a yes or no question about whether or not they decided to acquit on a murder charge, but weren't given the opportunity to. She doesn't want to make new law there. So, I mean, if she makes kind of new law here and just gives them everything, then, it's precedent setting maybe in Massachusetts. Bomb, 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 da-ding, da-ding. What movie was that? Name that movie. It's with Ben Stiller. And he's getting on an airplane and he goes to the counter to get a ticket. And the woman who works for the airlines is like, hold on one second. And she's like typing. And she's typing for like 20 minutes. And then at one point he says, somebody says, don't say bomb. And he says, bomb, 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 bomb. Wait, am I conflating my movies? Was that a Robert Downey Jr. movie? I think it was Ben Stiller. Is it Meet the Parents? Yeah. Thank you. One of the best movies. The other movie that I was thinking of is the movie with Robert Downey Jr. and I think Zach Galifianakis, and they make fun of Zach Galifianakis's perm like for the entire movie. And they get kicked off an airplane and they have to drive across the country together because his wife is giving birth. Robert Downey Jr. It's a hilarious movie. Anybody know what that was called? Are you a pothead fucker? I love it. I'm funny every day, Aizen. I'm funny every day. Sometimes you guys just don't get my notes. Due date. That was it. Due date. Ding, 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 ding. Wait. Mazzy got it. Mazzy got it. Due date. If you guys have not watched Due Date, hilarious. It is up there with We're the Millers, All the Meet the Parents. Thank you. Oh, yes. I told you. I watched 7 seconds. It was amazing. Oh, Scott. Oh, I don't know if Scott has. Okay. So let's see what else we can learn from the Gretchen Voss article that may be of interest to us in not only Karen Read's case, but other cases. So if you haven't seen it, I'm not going to read the whole thing to you because it's pretty long. But it didn't really paint Karen Read in a very positive light, let's just say. But here's what I find interesting. I'll slowly scroll in case you guys want to come back and read it later and, freeze on it and all. Where are we? Where are we? Oh, look at it right here. O'Keefe downed beers while Read drank vodka sodas. Lots of them. Little. I don't know. I don't know where she got that information from, but you know what? I would argue that the defense has a right to find out where she got that information from. So here they go. She goes on talking about the waterfall, talking about how O'Keefe grabbed a half-full cocktail glass off the table, took a slug, and carried the rest of the drink out the door with him. When they arrived at Albert's home, O'Keefe stepped out of the car. Read, though, decided to leave. Well, that's interesting. In her opinion. Or in her piece, that's what she says. She doesn't say Karen says O'Keefe stepped out of the car and she decided to leave. Because she does say several hours later at around 4:30 a.m., Read says she woke up alone in the same clothes from the evening before on the couch at O'Keefe's home. Then she goes on to say how she thought to call McCabe to ask if she'd seen O'Keefe. Read didn't have her number, but knew that O'Keefe's niece, who was close friends with McCabe's daughter, probably did. In a panic, Read woke her up and had her dial McCabe, who said she had no idea where O'Keefe was either. Then there's this. McCabe hung up and called Chris Albert's wife, Julie, who lived just a few doors down from O'Keefe, to ask if he had passed out at their house. Where did Gretchen Voss get that tidbit of information, do you suppose? Anyone? Anyone? Bueller? Bueller? Anyone? McCabe hung up and called Chris Albert's wife, Julie. I gotta highlight this for you. To ask if he had passed out at their house. I submit to you, she interviewed Jennifer McCabe for this article. Would those recordings be discoverable? Would those notes be discoverable? Would any emails with Jennifer McCabe become discoverable? I mean, what's good for the goose, right? And isn't Turtle Boy also a defendant in a witness intimidation case against Jennifer McCabe? Huh. Do the cell phone records that we obtained, I don't know if Olivia is here, but I know she would know this. The cell phone records that the defense was able to obtain for Jennifer McCabe indicate that she did call Julie Albert in the morning after Karen called her. She called her with a butt. Huh. Oh, but Julie said she didn't answer the phone. How long was that not answering a phone? How long was that butt dial? Butt dial pickup. So, did she butt answer? Meanwhile, Reed called O'Keefe's lifelong friend, Carrie Roberts, who also lives in Canton. Neither woman had seen or heard from O'Keefe. Where was he, Reed said she wondered. Well, you know what Carrie Roberts did do? She called Canton PD. She called Canton PD and she talked to Sergeant Good. And she mentioned something about a blizzard party. And despite her testimony, Carrie Roberts, that, that Karen was freaking out, saying he's dead, he got hit by a plow, Carrie sounds very calm when she calls Canton PD, and Sergeant Good answers and she says something like, yeah, my friend, she's just looking for a boyfriend. And, they were at a blizzard party, and she doesn't seem very shaken that Karen allegedly said to her, he's dead, he got hit by a snowplow, Carrie. So there's that. Linda Johnson says Julie said that she checked the next morning and saw the missed call. Interesting, though. Did she interview Julie for this piece? Well, let's move on because there's more. Within an hour, Reed, McCabe, and Roberts met up at McCabe's home, and after returning briefly to O'Keefe's house, piled into Roberts' car to look for O'Keefe. Well, you know what she didn't mention? That Karen didn't take her shoes off, so therefore she's guilty. Because she knew that he was never coming back. Well, thanks, Kelly. 1829 is the time stamp for Impact X. It was quick, but I noticed. Okay, so they mentioned my name or they show video? I'll check it out. 1829. Kelly says she saw something on Hulu about Delphi and that she saw me in it. And I was like, what? Nobody asked me to be in it. Thank you, Kelly. I appreciate you so much. Okay. So Gretchen Voss's article goes on to say, in the backseat, Reed screamed about her boyfriend being missing as the women drove through the pre-dawn streets of Canton, snow swirling and dancing in the car's headlights. On the dash, temperature read 18 degrees Fahrenheit. But she says somewhere in here, well, she must have talked to Carrie Roberts too, because she's got a lot of things that Carrie Roberts did and said. And she's a journalist, she has to confirm, right, her story. McCabe rushed over with blankets from the vehicle to warm O'Keefe and dialed 911 at 6:04 a.m. Did she run over with blankets and put them on John? Because I don't remember that part of her testimony. Is that what she told Gretchen she did? Anyone? Right. You mean a narrated audiobook? Sure. No, this is the old article. This is the article that they're looking for more stuff. They want all of her notes from this article now. All the stuff that other states would call privileged under journalistic privilege, but not in Massachusetts. This is what they're looking for. And then she says, a year later, the court case would blow up on local news sites and become the focus of conspiracy theories that ignited protests, ruined reputations, ended friendships, and divided the community of Canton, shredding the social fabric of the tight-knit suburban town. That's a nice analogy. So here's something interesting which I did not know. She talks about going to her parents' house in Dighton and curling up on the couch for 3 days after. The day she returned to her Mansfield home, and then it says here, she located an attorney, David Yannetti. When State Police Trooper Michael Proctor, a longtime Canton resident who was in charge of the criminal investigation, and his partner later came knocking, she answered their questions. It didn't say, and let them take her car. Or they took her car without a warrant. The day she returned to her Mansfield home, Reed says she was in her kitchen talking on the phone with a close friend who lives in Florida when she noticed a Chevy Silverado pickup truck parked in front of her house. Soon, she says, about 6 other vehicles appeared. Then nearly a dozen police officers converged. At 7:40 p.m., officers handcuffed Reed and drove her to the Blue Hills State Prison Barracks. I thought it said somewhere that Proctor was the one who cuffed her. Give me a second. In addition, it stated that Canton police found a broken cocktail glass and multiple patches of blood in the snow near where O'Keefe's body had been located that morning. They also found pieces of plastic, 2 red and 1 clear, in the same vicinity as the body. We don't even know where the body was. Items consistent with the broken taillight. She doesn't say anything about the solo cups. And then it talks about how she went into Stoughton District Court. She said there were dozens, O'Keefe's family and dozens of his friends and fellow Boston cops, including uniformed Boston Police Superintendent Chief Gregory Long, packed the courtroom. And then they talk about how the far more sinister theory came to be when Yannetti got a call from a tipster. It says the tipster, a man with a gravelly voice who initially offered up a fake name, picked up the phone and told Yannetti he recalls something to the effect of, "Your client is innocent. John was beaten up by Brian Albert and his nephew. They broke his nose, and when O'Keefe didn't come to, Brian and a federal agent dumped his body on the front lawn." An attorney for the man Yannetti identified as the tipster denies Yannetti's version. They go on to talk about how Brian Higgins was there. Given the new information, Yannetti and Reed say they began to believe that Reed was being framed. They hired a private investigator to knock on doors in Canton. Most people turned the gumshoe away, but Canton resident Tom Beatty, a friend of both O'Keefe and Reed, offered up a new tidbit. His daughter, who was friends with Brian Albert's nephew, Colin Albert, said that Colin had been at 34 Fairview the night O'Keefe died. Some of you might not know this, but here. When Reed heard this, she said, the news transported her back to a night during the spring of 2020 when O'Keefe's home security alarm went off and he bolted out of bed. She followed him down the stairs and says she remembered seeing Colin Albert and several teens in the front yard. "Go F yourself," Reed remembered Colin yelling at O'Keefe. "Get the F out of here," she recalled her boyfriend replied. The next morning, Reed says the couple awoke to a dozen empty Bud Light cans strewn in the bushes. The police were never called, but from then on, she says, there was bad blood between Colin and O'Keefe. In fact, she now adds, Colin was the only person with whom O'Keefe ever had issues. And then 3 months later, she had a couple over and they talked about stuff and things. I don't know who this couple was. They told Reed that Proctor was a Canton resident and had mentioned knowing members of the Albert family for years. All right, let me just take this off for a second so that I can find exactly what it is that I wanted to show you. One second. Talk amongst yourselves for a second. Somewhere in here, it says that she interviewed dozens of witnesses for this article. Or maybe it was in the papers. So do all those people whom she interviewed become potentially discoverable? I would argue yes, because she does go on in this article to talk about Aidan Carney and Jennifer McCabe and things that Jennifer McCabe told her. Like she was getting Facebook messages from people, threats from people. Better row, I would say. You need to request all this stuff. Just a thought. Just a thought. Let's take a look at the original, Judge Cannone's original decision on the original motion, where she denied it in part and granted it in part. Or do you want to watch a little bit of the hearing? Let's see how much time I have. I have some time. Let's watch a little bit of the hearing because we can see the hearing comes first. So let's look at the hearing. And then we can look at her decision so we have an idea of where she's going to go with it. This hearing was from January 18th of 2024. Except it's telling me that I need to restart my browser. Well, can you see it? I'll watch my screen and see if it comes up. It's always something. Oh, it's here. All right. No harm. Hello, Olivia. Hello, Olivia. All right, January 18, 2024. This was the hearing where the Boston Magazine attorney comes in for Gretchen Voss to argue. Ooh, she loved him. Remember this? Wait, can you not like hear it at all, or is it just low? Yeah, I thought that the sound might not be good. If the sound isn't good, then I just can't play it. Oh, you know what? Because it gave me that stupid I got to refresh my browser. Just hang on for 1 second. StreamYard told me to do it, and I didn't do it. So hold on. I'll be right back. All right, we'll try it again. If the audio is too low, we can't really watch it, but. And I remember that the only person who streamed this was like Canton Community TV. All right.
Last name is B like boy, ERTSCHE.
Okay. All right. Could you tell?
Representing MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right. So there is the Commonwealth filed a Rule 17 motion. You, as the third party or the record holder, have a right to be heard. So I'll hear you.
Thank you, Your Honor. There are really three documents at issue. Two recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Reed in the presence of her counsel.
Okay, you say almost entirely on the record. Could you
There
explain
are a
that,
few-
please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is a interview with Karen Reed alone at her home between Gretchen Voss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that.
Okay. Can I have only a mod answer whether or not you can hear the audio? Some people may be behind and they may not be able to hear it, but they're still chatting. So they're making it sound like they can't hear it, but they may be behind. Anyone? Oh, Patronus Glow is here. Hello. It's fine, just low. All right. It might not be worth listening to then. If you want to find it, you can go to cctv.-vod. So if you can hear it with your earbuds in, I'll continue to play it. But if people can't hear it, then there's no point. All right. If you can hear it, we're going to keep going.
Interview appear in the,
He can't find the mic.
in the article.
Just turn it up.
Okay.
Use earbuds.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed.
Well, that's where Hank Brennan got his information from, that these things exist, because he must have went back and watched this hearing.
That were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2
Okay.
because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Where counsel was present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself and to her children. She has received inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
She's in the courtroom.
Okay.
And So, and she says, that she's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
Yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, deep.
Okay, for those of you who are just joining who have so many questions, he's talking about Gretchen Voss, the reporter for Boston Magazine. The Commonwealth made a motion before the first trial. This hearing was in January of 2024 to obtain all of Gretchen Voss's interviews with Karen Read, the audio, the video, the notes, the emails, the text messages. They got some of the stuff. They didn't get the other stuff. Now, Hank Brennan has made another motion to get Gretchen Voss's stuff that was off the record because Massachusetts does not recognize a journalistic privilege. So while this hearing was in January 2024, these are the arguments Gretchen Voss's attorney will make again, because I'm sure he's going to come back and be like, yeah, no, we're not giving you that stuff. We told you last time how badly she was being harassed.
Detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a goldmine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Read had confessed in her interview with Gretchen Voss, that would have made it into the article.
Yeah, you think?
This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape, body language, physical reaction to a question. The same thing, these being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613, of the case that ultimately, when it went to the Supreme Court, became Bransford v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by too broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas Court said it may be argued that use of newsmen as witnesses is likely to result in unnecessary or burdensome or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion.
He added the her.
Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Bransford v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of matter of John Doe grand jury investigation to say that this balancing requires balancing between A, the public interest in having every person's evidence against B, the public interest in the free flow of information.
So you get his gist. Let's see what Lally had to say back to him.
Hear the Commonwealth, and then I'll give you a chance to be heard again, sir, if you want. All right, Mr. Lally.
Thank you, Your Honor. The nature or the chilling effect on news gathering in the council.
I just want to point out how rude it is that he stands up and has his back to the attorney for Gretchen Voss while he's arguing. He needs to go to the podium. It's just rude because he can't hear your argument with your back to him. Is this the way we do it in Massachusetts?
Alludes to in the motion in opposition as well as in argument, Commonwealth would submit as speculative at best. I refer the court to the decisions that are cited by counsel in the opposition, as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here, the source itself is not confidential. So we're not talking about a confidential source, we're talking about potentially confidential information. But notably, what's cited to our federal cases because there is no reporter privilege in the Commonwealth of Massachusetts.
That's right, folks. Doesn't exist.
What I would submit based on the Commonwealth's motion in submissions that there's not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition to cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else.
Oh, they are now.
The reporter's impressions or thoughts or.
Well, I guess Mr. Brennan doesn't agree with you because we just read his motion and he is looking for her attorney's statements too.
Any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. For 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these has met its burden under Rule 17 and would ask that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that. And
Sighing is killing me.
I would submit that, yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And
But now they want it all. Modulate your volume so I don't have to whisper. Look at his shoes. Oh, somebody just said, look at his shoes. Are we going to shoe shame? Are we going to shoe shame?
again, as it,
Oh, yes, we're going to shoe shame. We are. Can I zoom in on that? Let me see if I could zoom in on that for you. Remember the Telus trial? Oh, boy, he got shoe shamed a number of times with his little moccasins and his cheap sneakers from Ross. I don't know. Are these bowling shoes? I'm not really sure. Are those dress shoes that a man should wear with a suit? Who would not be caught dead in those shoes? John Ray. Anybody know who John Ray is? And his sartorial splendor. We are shoe shaming. We are. Hippie check, we're shoe shaming. Because its Birkenstocks are nothing. Birkenstocks are bust. All right. Modulate. Everybody modulated. Here's where I found it, and I knew I found it, and I found it for you because here's where it was. So that hearing that we just watched was on January 18th of 2024. And here's the decision, which was rendered on, sorry if I just made you dizzy, January 23rd of 2024, only 5 days later. You know how long some of the defense motions were outstanding? 70, 80, 90 days. Before we get to the order, let me get to some of these questions. Romy with a $50 super chat. Thank you so much, Romy. Could the defense team request WBZ to provide the name of the person who informed David Wade about the existence of ring footage reported on 2/2/22? That's what I'm saying. That's what I'm saying. Because from the beginning of this case, from the day of Karen's arraignment, it was reported by WBZ. Were they the only ones? Because everyone picked that up like wildfire. We looked at it one day. The Daily Mail had it in the UK, like within hours. Something like, sources close to the investigation tell WBZ investigative team that there is ring camera footage of the incident. And you can still find it. It's still out there. It was never corrected. It's a great point. If you send me an email, I'll forward it along to, I'm just kidding, I won't. But that is a great, I mean, look, there's no journalistic privilege, right? So that means if they have a source, whether it's confidential or not, everything should be fair game, Romy. Look at Romy. Romy, you may have cracked another great thing for the defense to do. Thank you for that. Kirsten, formerly Auntie Bev's verdict form. Thanks for tuning in from Canada. What are the chances Bev allows any part of third-party culprit in this time around? Well, she did allow it in eventually last time. She was mediocre. Yeah, I mean, the door was opened and they were allowed to argue it in closing. And you remember that because two of the third-party culprits that they pointed the finger at were sitting across from the jury staring them down. So We will see. Gamer Ducko, thanks for the 15. I'm going to court on March to claim damages following a car accident. Thanks to LawTube coverage, I wasn't scared of the documents. Thank you. Thank you. Thank you for watching. And Shari D for gifting 5. Thank you so much. I appreciate you. Glamma says she did not interview Jen McCabe. She interviewed Kate Peter as their representative. Well, she interviewed dozens of people, Suze. So I'm going to tell you how I know that. Because here it is in the order. This is the memorandum of decision and order on Commonwealth's motion for records. When she goes on to talk about her reasoning, this is a 9-page decision. She says, Voss interviewed dozens of people for the story, including the defendant. Dozens of people. I'm just saying. Any of those are the people, defendants in any other case, because perhaps it would be discoverable. Perhaps the probative value of such things would outweigh the prejudice. Footnote 1 says Voss submitted an affidavit in connection with her and Boston Magazine's opposition to the motion. So she did not only interview Kate Peter, dozens of people. Maybe they should just ask for a list of all the people that she interviewed, because apparently nothing in Massachusetts is privileged with regard to reporting. Thank you, Kim. Thanks for the 5. If his contract ends on June 30th and the trial lasts longer than that, then what? Well, they can always extend his contract. Ken Mello's contract, who's the other special ADA that was appointed to prosecute Aiden Carney, aka Turtle Boy, had his contract extended, and also his cap was extended. I think he's been paid something like, you can correct me if I'm wrong, more than $80,000 to prosecute Aiden Carney. And now, because Ken Mello has maybe made himself a witness and he's kind of been MIA, there's another special ADA that's assigned to prosecute that case, and that's Robert Cosgrove, I believe. So yeah, they could always extend, or if he chews up the $75,000 cap, he can also ask for a bigger cap, because they've got all their eggs in the one basket with Hank Brennan. Nobody in the Norfolk County DA's office, according to Vanity Fair, wants to touch this case. Thank you, Linda, for the Canadian super chat. Brother counsel, something, law to talk, Supreme Court, Karen Reed appeal. I can't. I don't have the brain power right now to try and decipher that. I'm not sure what that means. Tracy, why would John O'Keefe go to Chris's house if they were not at 34? Great point. Great point. Who gave Gretchen Voss that information? I mean, I don't think she's relying on Karen telling her that. Did she interview Julie Albert? Did she interview Jennifer McCabe? Things that make you go, huh? Dozens of people. She interviewed the defendant 3 times. She goes on to say in her 9-page decision, she promised the defendant to keep the interview off the record. And then she goes on to say, as an initial matter, I don't think we heard this part of that very adorable attorney, brother counsel. Oh, brother counsel is another law tuber. Right, but I couldn't decipher that message. He's inviting me to come onto his show to talk about Karen Reed? I haven't heard from him. Or is she telling people to go watch his show? I have no idea. That's why I couldn't understand. No, if you see, here's the thing, Team Brittany. If you tag me on these messages, StreamYard does not tag me, so I can't see them. I have to be looking at 2 different devices to see if I'm tagged on anything, and I don't see it. The only thing that is good that StreamYard does for me is it puts the super chats into a whole separate column. So that's the problem. I can't see anything that's tagged, and I can't have YouTube open in another tab on my thing because it's like It's just too difficult. And then when I have the screen enlarged to read it, I can't see the chat. So thanks. Unless that was with regard to the thing that I just read. So Boston Magazine and Voss agreed to produce the audio tapes from the on-the-record interviews. And so, as we know from reading Hank Brennan's new motion, they did obtain those. And he listened to all of them. But that's not good enough because he wants some admissions from Karen Read about her alcohol intake so that he can try to further prove that she's intoxicated. And then she goes on to say, thus, the focus of this motion is any off-the-record statements made by the defendant in the audio recordings from the on-the-record interviews and Voss's handwritten notes of statements made by the defendant during the off-the-record interview. And to obtain such records, there's a test, and they need to show that their request meets the requirements under Rule 17. She says in footnote 2, Judge Cannone, it is unclear to the court whether the defendant also made off-the-record statements during these interviews. Well, Hank Brennan said, I listened to the tapes and, there's some redactions, so we should get it all. He still owns his first pair of Dockers. Are they Sperry's or Dockers? Wait, are Dockers shoes or pants? Didn't they used to have slacks that were called Dockers also? In addition, here in footnote 3, Hank's really reviewing the file, you guys, because he's got the deets on the sitch. He's got the intel. He's got the info. In addition to 3 interviews, counsel for Voss and Boston Magazine stated at the hearing that Voss and the defendant also exchanged text messages and voicemails, which are in Voss's possession. Whether such communications are subject to disclosure was not briefed or argued by either party, and therefore the court will not render any ruling with respect to the text messages and voicemails. Well, that's because he just kind of brought it up, I think, when he was arguing. Brother Santa Claus. Docksiders are shoes. Dockers are pants. Thank you, Mudrucker. Thank you for schooling me on Massachusetts fashion. What about Vinnie Vines? People still wearing Vinnie Vines? It's Vineyard Vines, by the way, and they call it Vinnie Vine. They called it Vinnie Vines in the Murdoch trial, and it just really offended me. I don't know why. Okay, Joanna been off topic, so maybe later. Well, too late because I already pulled it up because I saw it come by. What is the Captain Jack line in your intro song? It's been stuck in my head. I can't figure it out. Captain Jack. Maybe it's something like Captain Jack sings and his piano plays, something like that. It's obviously it's a nod to Billy Joel, based on my Long Island heritage. Thank you. Thank you. Thank Melisa, Turd Ferguson for that. And thanks, Susie Q, for becoming a new member. So she goes on at great length and says statements by a defendant regarding crimes for which he is charged are evidentiary and relevant to a criminal prosecution. The defendant voluntarily made statements to Voss regarding the events that led to O'Keefe's death, and such statements are admissible pursuant to the Massachusetts Guide to Evidence. The material sought is only in the possession of Boston Magazine and Voss. It cannot be procured by the Commonwealth without compelled disclosure, and its production is necessary in advance of trial. Oh, Bettero and Turtle Boy, I hope you're listening. Kate Peter talked to Gretchen Voss. She bragged about it. And then she says, because this case concerns the compelled disclosure of confidential information provided to a journalist, the court must also balance the public interest in every person's evidence and the public interest in protecting the free flow of information. It did kind of look like bowling shoes, right? Maybe he was hitting the lanes after work, right? Maybe he's on bowling. Maybe he's on a league. talking about Gretchen's affidavit, her affidavit, which we don't have access to, I believe that was sealed by the court. Her affidavit also details the harassment she's endured since the publication of her article and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. Okay, Bev, that was in your order last time. Are you now going to turn around and say you're going to disregard that and just give it up? I mean, I don't think there's going to be anything in there that's helpful to the prosecution. And it is worth pointing out also that the defense did not oppose this motion last time when the Commonwealth made it. They took no position on it. They didn't get up and they didn't put any opposition to it. It's like so bright. She also goes on to say that her fears for her own safety and that of her family are no doubt warranted. She says the Commonwealth has also articulated a strong interest in obtaining the information sought for the defendant's criminal prosecution. Although it's a close question at this time, the court does not view the Commonwealth's interest as outweighing the concerns articulated by Voss. However, if, after reviewing the redacted on-the-record interviews, I can't highlight for you now. Come on, stop. The Commonwealth believes it's entitled to further information. It is not precluded from reasserting its motion to this court. Okay, it's also important to point out that after all of this shenanigan rigmarole, they never called Gretchen Voss to the stand in the first trial. They never called her. She was in the courtroom every day, taking up a media seat. So there's that. But now it's so important because I think Hank Brennan is realizing how weak the case is. He's looking for something else. He's looking for admissions, for Karen admitting that she was hammered. And I don't think he's going to find it. But he's going to give it the old college try. Then she says, order, for the foregoing reasons, the Commonwealth's motion for records is allowed as to the portions of the audio recordings of June 30th, 2023 and July 13th, 2023 interviews that were on the record. The motion is denied without prejudice as to the portions that were off the record. And as to her handwritten notes of the July 7th, 2023 interview. So there's that. Without prejudice means you have the right to renew this motion later. When a motion or anything is denied with prejudice, it means that's it. You're done. Don't ask me again. Don't ask me again. Don't even ask. The answer is going to be no. Oh, thanks, Samuel. Thanks, Samuel. Thank you for saying that. I'm smart. I appreciate you. You know who's really smart? You know who's wicked smart? Andrea Burkhart. Like, she's scary smart. Which, by the way, are we on Verdict Watch on Delphi yet? Because I've been prepping this show all day, and I have not, as such, had an opportunity to look and see if closings are done and we're on Verdict Watch. Anyone? You guys can tell me. Thomas, even if she did, how can you come back later and prove that she actually was drunk without a BAC from that night? Well, they tried. In the first trial, they tried. Her blood was taken because she was sectioned. She was brought in on an alleged involuntary hold, but she was quickly released after they realized she was not a danger to herself or others. But that's how they got a blood draw from her. They didn't specifically test as they would in a drunk driving case, but there was an ETOH, or you guys can correct me, sort of reading in her CBC or whatever they did that they tried to extrapolate, but it's not the same test that they use in drunk driving cases. So it's all speculative. They can't, it wasn't like she was arrested at the scene right after an accident as someone would typically be, right? Because who's to say she didn't go home and drink? I can't believe that evidence was even allowed in. I mean, it was allowed in. The jury was allowed to assess the weight of it, but I don't know that it should have been admissible. Why is Karen's drinking an issue? They were all drinking and driving, but they're not all on trial. She's the only one on trial. Doesn't matter. Doesn't matter what anybody else was doing. They're not on trial. They weren't pulled over. Right? Would it be a good or bad strategy for the defense to agree to allow it in if they're also allowed to bring in the Marcy video? You can't really stipulate to stuff like that, because even when they tried to stipulate to stuff like that, they stipulated, remember, in pretrial motions in lemonade, they stipulated, both sides said, we don't want anything to come in regarding, correct me if I'm wrong, the harassment. And the judge said, well, I don't care if you want it to come in. If a witness brings it up organically, it's going to come in. And that's what they did, the witnesses. So apparently stipulations don't really mean much to this judge anyway. Right? That's right. She wasn't arrested at the scene because there was no scene. Which scene? Do you mean the scene at 34 Fairview? Or do you mean the scene at the Canton PD? What scene? Which scene are we talking about? Oh, thanks, Karaoke, for loving my show. I appreciate you so much. I appreciate you. All right, guys. Final thoughts, questions, concerns, comments before we wrap up this stream. Oh, thank you, Jenny, for the Venmo. I appreciate you so much. She's like, unfortunately, I'm driving and I can't. Cheers to justice and the success of my channel. Oh, thank you, Jenny. I appreciate you. You're very kind and generous. We'll see. We are coming back. Of course, we're coming back because this is the case that will never end. So we're going to come back. Let me look at my calendar for a moment. We're coming back next Wednesday. And there's a motions hearing at, I think it's at 10 a.m., but I'm going to cover it live with you. Thanks, Olivia, for chiming in on this. It wasn't even a blood draw for BAC analysis. It was a standard panel performed under an involuntary hold. This blood poll completely violated MSP's own rules for reliability for BAC tests. And see, that's why I surround myself with the really smart people who can explain this stuff to you. I don't think it should have been allowed in. Good thoughts for Richard Allen. Yes. Oh, yes. Oh, yes. And they all brought it in inorganically. Yeah. You remember. Yep, they will. Absolutely, Jadzia. They will be wanting 3 days worth of notes from Vanity Fair. 100%. They will. Thank you, Kelly Reed, for tuning in. We are praying for your family today and every day. As always, my friends. Laura G. Gibbons. OMG, I just came in. What did I miss? Oh, you're funny. You guys are funny. You keep me laughing. I love you all. Thanks to the mods today for keeping it classy. This is always a hard topic to cover because, it's a little vitriolic and stuff like that. So if anybody sees anybody on Twitter trying to teach the law to everyone about third-party defendants and when they can be third-partied into a civil case, you just tell them that it's 100% going to happen, and it can happen. And you can also tell them that people are not found guilty in a civil case. They are found liable or negligent, if you prefer, or responsible. So there's that. Notorious, yeah. It's everyone's favorite words. Favorite word. All right, you guys, be cool, be kind, be classy, be nice to each other. Stay safe out there. Thank you to the mods, members. Do all the YouTube courtesy stuff. Smash the like, share the stream, subscribe. It's free. Remember to hit the notification bell so that you will be notified when I go live, because I don't really have a schedule. I just go on when I feel like it. And oftentimes I only schedule things an hour or two in advance because, I'm a busy mom. I'm a busy mom. Prayers for Duty Ron as well. I saw he posted a cancer update. I have not seen it, but of course, as always, prayers for Duty Ron. Be cool, be kind, be classy. Did I say that already? Peace. I'll see you soon.